Well, I can see that more and more people are joining. We did say that we'd start on the half hour, I think 8:30 in London and certainly 5:30 here in Sydney. And we have Amsterdam, who will be in the European time zone, but we have Shanghai here as well on the attendee list. My name is Gillian Davidson, and I'm a partner here at Spark Helmore. And I sit on the GILC board, and I with a special focus or responsibility for the Asia Pac region. We're really thrilled to see so many people are interested in what for us is a relevant and important topic, focusing on that, what certainly for us here in Australia has and I know in other countries around the world, has been what I would call the mystery often, or the unfathomable way of how you best undertake recoveries in the Chinese market. And the great thing about GILC is that we have a tremendous firm as a member of the network, Buren Legal. And today, Li Zhao, who is the partner of the Chinese practice and is based in Amsterdam, will be talking us through how we might approach recoveries in China. She's joined by Jing Wang, who is in Shanghai, and I've had the pleasure of spending time with Jing Wang when GILC had some meetings in Shanghai at the end of last year. That dim distant past when we could actually travel, and we took it for granted. And as we flew from I think a meeting in Seoul into Shanghai and Jing Wang, it was great to spend time and to meet the insurer clients and connections in Shanghai. After we've heard from the Chinese side of things, Spark Helmore is going to give you a bit of a perspective on the market in Australia, in particular, with a particular focus on the challenges that you face when an entity is not solvent. And I'm really grateful that Nick Christensen, a partner in our corporate and commercial team with a particular focus on litigation and insolvency, is going to help step us through that. And we also have James Clossy, who is a senior member of the commercial insurance team in Sydney, and he'll support Nick on that discussion, perhaps with more of an insurance perspective. So that's how we're going to run through today. There is an opportunity for Q&A on this marvellous thing called Zoom, and down the bottom of your screen under the slides, you'll see the actual Q&A tab. And if you type into that, your questions will come up and the panellists will be able to see it, and then we'll be able to respond. But we're really keen to get some interaction at the end of the webinar. Yeah, so hang around or send your questions through, and I'm sure the panellists will endeavour to address them. So I just wanted to do a little bit of an introduction as to GILC for you. So currently we've got 17 or maybe, yeah, close to 17 members around the world. So you can see that there's a good connection there in Europe, and in the Asia Pac we have Li and Li in Taiwan, and Kaitan in India, Spark Helmore down in Australia. And on that motive there, you will see that you'll see Italians and Spanish, and then you'll see the Americas as well are identified there. So the point about the Global Insurance Law Network is that really is all we talk about, if you like, or what we always have a focus on is insurance. And the great benefit of coming together as a global network is actually being able to dig into issues which apply to our clients across the globe. And certainly this initiative is one of several that we've had where we've tried to take a broader look at the issues and the opportunities. So enough from me. I've introduced you to the panellists, and I will run through those names with you. And so perhaps now we just might hand over to Li and Jing to step us through their presentations. So thank you.
Thank you. Thanks a lot, Gillian, for the nice introduction. It is indeed a great pleasure for us, Bureau Legal, to work together with your firm, Spark Herma, to jointly present this webinar. And I also like to thank all the attendees for taking time to participate in this webinar related to China. Recoveries in China is indeed a very broad topic, even in the context of subrogation claims. And in the next 30 minutes, my colleague Jing Wang, based in Shanghai office, and I will discuss some primary concerns for foreign business to seek judicial relief and remedies before Chinese courts. Partly are general issues for international civil litigations in China. And in Chinese terminology, we call foreign related cases, anything involving foreign elements. And partly are specific for subrogation claim. I think as Gillian just mentioned a bit, foreign companies doing business in China and with China are commonly concerned about the ability of the Chinese judicial system to protect their legitimate business interests. To many foreigners, the Chinese people's court system are mysterious, particularly when dealing with international civil litigations. Despite the fact actually China has been opened up to the outside world for more than 40 years, and also undoubtedly the important role of China in the global supply chain, if we're thinking about the current situation during this special period. And many foreign business, according to our experience actually, also many foreign business owners are hesitant to enter litigation in China because they assume that the legal process in China is kind of like a time-consuming nightmare filled with red tapes, corruptions, and that after all the stress and waste of time, they will be unjustly treated and left with nothing. But to be fair, I must say, the impression portrait, I just portrayed actually, I think sometimes it's more often as a result of misunderstanding, your own weak cases, poor strategy, or careless implementation, but not necessarily the fault of the Chinese legal system. Of course, having said that, compared with the common Western litigation process, Chinese litigation indeed has very unique characteristics. But in our view, if you are well prepared, if the foreign business has a thorough understanding of the China's legal system, they actually can benefit from its utility. I don't think I need to say much about the principle of subrogation to today's audience. Of course, I think most of you knows like it means that the insurer who has settled a claim may then step into the shoes of the insured, the policyholder, to try to recover what is paid from anyone who has contributed towards or caused the losses. Chinese law actually follows the same principle, the same logic here. Chinese courts acknowledge the right of the subrogation is in essence a legal transfer of claim right. And thus the legal application of disputes of the claim right is determined, eventually determined by the legal relationship between the policyholder, the insured, and the third party. The same logical, the same principle like all other jurisdictions. And of course, to bring your claim before a Chinese court, there are certain issues, this is the topic we are going to discuss today. First, I'm going to mention a bit, a brief overview of international civil litigation. Actually, I think I already started. And then I will focus, more related to subrogation. I will say something about this is a key issue here, the recognition of the right of subrogation by Chinese courts. And then I will hand over to Jing in Shanghai, and she will deal with more specific issues related to the insurance subrogation claim in China. Especially, I think one of the most important issues here is about the foreign expert report. And lastly, of course, the goal is not to just win the case, it's about to get the payment, to secure the payment. So a very practical issue. Is it possible to get to obtain the interim measures and how to enforce your judgment in China? And then the key considerations. I think before, I'm talking about to prepare your case. So there are some very key considerations here. I will not go, because the limit time here, I'm not going to go through the whole list. We have some slides to be to elaborate on certain issue later, and some I think I just quickly go through. I think the first one is about whether the plaintiffs and the defendant are suitable, because in reality we normally see the Chinese manufacturers, they do not enter into the contract directly. They will do it through like a Hong Kong-based trading company, and then actually your case, if you claim the damage against the Hong Kong trading company, it's in the jurisdiction of Hong Kong, not mainland China. And even, you know, based on the tort, based on the product liability, you're going to claim to sue the Chinese manufacturers. What we see more often is, you know, sometimes it's quite difficult to identify which manufacturer because of the limited information. You don't have some small details. You don't even have the official Chinese name, which actually doesn't matter a lot. It takes out some more time to find out which exact entity here. And also about the supply chain, we also often found like the policyholder does not well record the whole supply chain. That means the evidence itself is not solid enough. Limitation period, we'll talk about later. Cause of action, what is the cause of action? We're talking about, it's about the insurance relationship with the third party. And normally on the Chinese practice, it's either based on contract, international sales contract, or the product liability. And the competent court will be decided by Chinese court based on the rules. And it's possible to create a kind of like a connection to a top tier city court, which we normally recommend, because the judicial independence or the professionality and the quality of the cases management in Beijing, in Shanghai, are much higher, I must say, than in some second tier or even smaller cities. But there's a kind of like a strategy how to create your case, like a connection to the jurisdiction in top tier cities in China. And the applicable law, normally in most cases, Chinese court will apply Chinese law, but we do not exclude the possibility of the application of foreign law according to Chinese conflict of law rules. But it's too legal maybe, so we leave it for the time being. And of course, you have to carefully think about your claim amount, how can damages and losses be calculated. And lastly, that's the issue will be discussed with Jing. Okay, then we quickly move to the next slide, is about it's just an overview of the status of liability litigations in China. I just want to highlight one point here, because of course people think when you enter into contract with manufacturers in China, you know, in most cases, they are small and medium enterprises. And statistics show actually the product liability insurance, especially for the export product liability insurance, the coverage rate is quite low. I think it's less than 10% even for these days. So it's quite often like you will find the manufacturer, they don't have any export product liability insurance. Okay, and next one. Yeah. But, you know, when you have the case, and a lot of people, foreign business, they are not aware, is actually you can find a lot of information about your Chinese manufacturer online on database. And we have this database, kind of like the Business Registry of China. They publish online all the details of the company, general information, and in some cases, even the financial information. So you can have kind of like a full picture of the track record of the company, and even some, you know, financial information, but not always the case nowadays. And more importantly, you can see whether they have subject to any like administrative penalties to show whether the company, you know, operation on the normal conditions. And besides this, we also have the digitalization of all the court decisions in China. So you can also find the Chinese manufacturers, whether they involved in any like litigation cases in the past, or whether they are subject to any enforcement orders, whether the company itself and the senior executives are listed in a list we call dishonest persons. If you found that they are on this list, then it at least is kind of like an initial indication, either the company is within some financial problem or in bad faith. So actually this kind of like a search is quite useful in practice. And we normally can help the client to make a very comprehensive search report on a particular Chinese entity. Yes, and the next one. Yeah, limitation period. Yeah, just for the subrogation claim, it depends on, for the contract, international self-contract is 4 years, and for the product liability, normally it's 2 years. And of course, we will advise the client to calculate whether it's still within the limitation period or if it's going to end very soon. And of course, I think the normal strategy is to issue kind of like a demand letter to interrupt it, to have it restarted. And what we normally do, actually, we will suggest the advisor client to issue the letter by a Chinese local counsel with our affiliated litigation firm in Shanghai. We can do that, and always include a Chinese version and manage the whole process in compliance with the Chinese evidence. So to do it very effectively, actually, we will not recommend like just a foreign law office to issue such letter, rather leave it to a local counsel, yeah, to maximize the effect here. And for evidence, I just want to like to stress on that in the Chinese court system, the written evidence, documentary evidence is the key. It's a strong focus on the written evidence and adhering to the strict evidence rules. And judges actually are inclined to express their opinions in the early stage through, the person, we can access to the judges without the presence of the other party, and to preliminarily discuss whether the evidence is satisfactory or not, whether we have to supplement any, this is kind of like common practice in China. And there are some recent changes on the requirements on the notarization and the legalization. As some of you may hear, like for the litigation cases in China, you have to notarize, legalize everything, every piece of the evidence. That's not the case now. You can determine actually whether to legalize certain evidence according to the needs of your case. So I think this is also shows the attitude of the Chinese court to kind of like facilitate the foreign business to do litigation in China. I think this is kind of like a positive signal. And how the local courts going to implement these rules, we are still waiting to see. Okay, next one, this is about the evidence and about the duration of the court proceedings, just to give you an idea here. And we have like 2 trials, 2 instances, and you can have the final legally binding judgment here. And the first instance, there's 6 months and could be extension to in total like 15 months, and the second instance. But I put something in red here. Interesting thing is, according to the current rules, the foreign related cases, actually judges has the discretionary power to extend the time limits. So that's, I think, one of the reasons why the foreign business gets the impression that the Chinese courts do not, give priority to their cases or just delay their cases. I don't think that, I think this is more about the Chinese judges. They just make use of the current rule and just to handle the cases which has a very clear time limit according to law, because there's no statutory time limit for the foreign related cases. So I think that somewhat is understandable. They just postpone it as much as possible. Okay, and then the second topic is about obtaining your subrogation right. I think the key issue here, there's 2 key conditions. One is you have to prove that the insured, the policyholder, have the right to claim the corporation for losses from the third party. That means the insured accident is caused by the insured. And another is about the insurance payment. The insurer has to prove that the insurance payment has been made. And recently the Chinese Supreme People's Court, in a case, they have the opinion that for the Chinese court to examine the case, they should only focus on the payment and whether it has been made. Whether the insurance payment is made according to the governing law or is reasonable, it should not be the scope of the subrogation claim in China. So this is the SPC opinion. It's a case last year. But the focus, I think, of the Chinese judges, according to our experience, is still they will focus on the compensation, whether paid pursuant to governing law, like English law or Australian law. So, in the Chinese legal system, actually, the lower level courts, they do not necessarily follow the opinion of Supreme People's Court unless it's a guiding case. So we still to see whether this SPC opinion will be followed by more and more local level courts. There's still certain inconsistency in the whole system. And there's still, this is a positive said, and I also I also put a negative list, the next slide. There's some potential grounds for denial by the Chinese courts, and expect for like, some obvious ones, like the damage are not caused by the defendant, by the third party, or the damage made are not due to the infringement, a default of third party. I think there's an interesting one here, is after the insurer has made the insurance payment to the insured and then the policyholder waives the right, actually the Chinese court require the insurer should exercise certain reasonable duty of care. That means you have to be, to have the duty of care to know or should have known that the insured has waived its right. Then you can claim such waiver of right is invalid. Otherwise, if you cannot prove that, for example, during the process of executing the insurance contract, you did not ask for the underlying contract, you did not make the necessary inquiries, then the Chinese judge will say, okay, you do not exercise the reasonable duty of care. You should have known the insured has waived its right. So you cannot use the waiver of right as kind of like a defense, say such waiver is invalid. I think this is quite interesting. So make sure that you have all these communications and inquiries and everything is well recorded to see during all the process you have exercised the duty of care. I think this is, this is evidenced by more and more case law in China. And this is an interesting development, and also show the Chinese judges actually are getting more sophisticated in hearing this kind of subrogation cases. Okay, this is my part. Maybe I go through too quickly, but if you have any questions, just feel free to let me know. And then I hand over to my colleague, Jing. Thank you.
Thanks, Lee. In the next part of my presentation, I will talk about key evidence to which insurers and business should pay close attention when contemplating preparing a cross-border recovery or subrogation actions. Interim measures and judgment enforcements also will be touched upon at the end. So under Chinese civil procedure law, in principle, the burden to establish and prove the truth of a case rests upon the claimant, and that's otherwise stipulated under the law. This also applies to cross-border recovery actions for overseas insurers. Generally, it's their responsibility to adduce evidence to prove their claims. The responsibility can then be shifted to the defendant if it is proved above certain statutory standard. Now, here is a general list of the evidence to which insurers are advised to pay close attention. This includes evidence relating to identity, that is the identity of the claimant, legal standing of the insurers, is it lawfully established and still existing, the chairman of the board, director, etc. Generally, this would be issued by company registry or any competent authority which is responsible for registering companies' information in relevant jurisdictions. Evidence regarding occurrence of accidents, maybe newspaper release notices, reports or announcements issued by the relevant authorities. For example, fire brigades. Evidence regarding product source, where was a particular product originated from, who would be the manufacturer that actually produced or supplied the product. Insurance may need to retrieve documents that were produced a long time ago from their issued client, such as sales and purchase contract, supplying contract, invoices, shipping documents, etc. Course of action evidence to establish defects or products and causation is usually covered by and explained in grey bands in expert report. We will discuss it a bit more detailed in next slides. Evidence regarding losses, particularly maybe, actually I haven't finished the first slide, sorry. We might go back a little bit now. So evidence regarding losses, invoice, yes, invoices, written proof of their necessity and reasonableness. Insurance policy, payment of insurance premium is to prove the establishment of contractual relations between issued and insurers. well-recorded claims, handling and settlement process, the key focus should be placed upon written proof of the indemnification process. This is to be evidence that the insurers have indemnified the issued and have obtained the title to launch a subrogation action against Chinese manufacturers. Correspondence between the issued and manufacturers to rule out flaws should not be overlooked either. Defective parts or parts of the product, if possible, if these parts or the defective products were to be shipped to China and still remain intact, just in case there might be a second expert evaluation, which may take place in China later on. Right, next slide, please. We will now discuss a bit more about foreign expert report. Foreign expert report, what is it? It refers to the official report issued by qualified foreign experts where they are investigating, discussing and determining causes of accidents. But before diving in the foreign expert report, I would like to briefly introduce the Chinese expert report and the procedure through which such reports are produced. Basically, to determine the critical and technical issues in a claim, such as the exact cause of an accident, the defects of products, a procedure called judicial authentication, or otherwise known as expert evaluation, is often utilized and has been widely adopted by Chinese courts. So generally, there's a list of Chinese companies and institutions with recognizable qualifications and experts in a wide variety of fields will be available, from which the claimant and defendant may single-handedly choose one to conduct the procedure and then present reports in supporting their claims. Mutual appointment is also available and acceptable. However, if no agreement can be reached between both parties, courts are empowered to appoint one from the list. After expert reports are produced, they should be cross-examined at the hearing. Here, you can see I put down Article 36 of the newly amended evidence rules to illustrate what are required to be included in the Chinese expert report. So we can just quickly go through it. Names of the court, instructing courts, contents, and requirements of the instructing expert opinion, material, principles, method, explanation on the process, the expert opinion itself. Also the report, the Chinese expert report should be signed or sealed by the expert or the institutions with qualification certificate of the expert report of the expert attached. However, when the expert reports are issued by foreign institutes, the application of these reports before Chinese courts are often riddled with uncertainties. There are few reasons contributing to this. Firstly, Chinese courts often find it difficult to verify the credibility of foreign expert report because its non-Chinese institution is not to be included in any official list of this judicial authentication. Secondly, the conclusion foreign expert report draws and the wording of which sometimes suggests there are a number of different causes or likelihood. The conclusion is inconclusive, although quite reasonably so sometimes, but this makes it difficult to prove on the high probability that an accident was more likely to be caused by one particular reason rather than others. So how to bridge the gap? How to enhance the credibility of foreign expert report? Well, it will be reviewed in the next slide, thanks. In terms of the formality, foreign insurers and companies can include or may include the foreign parts in the foreign expert report, just so as required for Chinese judicial authentication expert report. So insurers might think that they need to include names and titles of party which gives the instructions, materials of authentication, basis of appointment, scientific technological means adopted, details of the process, definite and clear authentication, conclusion, qualification and signatures of experts, and the official seals of the institutions. Plus, like all the evidence produced outside the territory of PRC, China, foreign expert reports should always be notarized, legalized, and very importantly, translated carefully before submitting to court. Anything else insurance can do to enhance the credibility? Yes. Next slide. They may want to reach mutual consent with other parties on the choice of expert beforehand. They can seek second opinions and comments on the admissibility and value of foreign expert report from qualified Chinese experts in the same field. They may want to gather original qualifying certificates, introduction of the experts and the institution as much as they can. They may want to conduct judicial authentication on the defective product if they were to be shipped to China. They also want to ensure there's a clear conclusion to include in the report as to the causation and the loss. They can also summon experts to attend the hearing as expert witnesses. Last but not least, they need to make sure that there's a complete evidence trend established with each evidence corroborate others. Now we will move on and briefly go through two procedures that the insurers may initiate against Chinese manufacturers to secure the best financial recovery from them. So the first procedure I would like to talk about is in interim measures with special focus on the property preservation. So the main interim remedies available for both parties in civil and commercial litigation proceedings would be preservation of property, preservation of behavior, preservation of evidence. So preservation of behavior sometimes known as injunctions in other jurisdictions. There's an order of preliminary enforcement. In this part, I will focus on property preservation. So what is it? Property preservation represents a series of measures that court may grant applicants to take to stop the defendant from disposing their property before a judgment is delivered. What kinds of measures are available? There are three types of measures: seize, seizure, distraint, freeze. Each represents seize real estate property, distraint, movable asset, freeze bank account. Are they available pre-action or post-action? Whether the measure can be taken before a case is filed to court or after. So, post-action in principle and pre-actions acts and exceptions. Usually, Chinese courts are very cautious in granting application before the court, before a case is even filed. Only under limited circumstances, upon fulfilling certain conditions, would court be willing to grant such applications. It's possible that courts in different regions in China make orders differently given the circumstances and the local practice. So actively consulting local practice is the key. In practice, insurers are often advised to file a lawsuit and at the same time submit the application for property preservation. Next, online enforcement monitoring system is quite useful to help insurers to find out, to search for the property clues, the whereabouts of the property, the size of property, etc. So security, provision of security by applicants generally, in most cases, courts would request the applicants to provide security when the application is submitted. This is to cover potential damages or loss the defendant made or may suffered due to wrongful preservation. However, there are a few exceptions. I would particularly like to mention the last one, as it gives an exemption for insurance companies and branches. However, it's possible that this exception may not apply to foreign insurance because they are not set up after being approved by Chinese financial regulatory authority. Again, however, prior consultation with local competent court is the key. So about the forms of security, what are they? A sum of money, cash, real estate mortgage, letter of guarantee issued by banks, financial institution. A letter of guarantee can also be issued by Chinese insurance company. This is based on property preservation liability insurance purchased by applicants. Premium is usually around 0.1 to 0.8 of the value of the property being preserved. So good news for foreign insurers if they don't have assets within the territories of China and that find it or struggle to make international remittance of a large sum. Sometimes it might not be straightforward in practice. However, to note that the letter of guarantee cannot be issued by foreign insurance or members of international group clubs, for example. Finally, if all go well, and foreign insurers do manage to secure final favorable judgments against Chinese manufacturers, they will need to enforce such judgments. That will be talked about, yeah, next time, thanks. Insurers would therefore be the judgment creditors and the manufacturers could be the judgment debtors. But within 2 years after the final judgment is delivered, judgment creditors should file an independent enforcement case with enforcement divisions in the court. An in-charge enforcement officer will be assigned to handle enforcement process, who shall issue a notice of enforcement to enforcee and may thereafter take relevant measures if the judgment debt fails to honor the judgments. What are the measures available? A bit similar to the measures available for property preservation. This is to suspend, freeze, and transfer or sell judgment debtors property, to withhold their lawful income, to evict them from the house, to compel performance or rent third party to performance at their expense. In a worst scenario, when when the judgment debts are not honored after all the notices have been sent out, have been issued, there will be escalated measures, the punitive measures when they are not honored. So a judgment debtor will be inhibited, for example, from crossing borders of the country. This is called a ban on leave. They may be inhibited from conducting high-level consumption activities. There may be blacklist or put on list of the dishonest person, and the facts of the debt evasion could be circulated on media. So, and that about wraps it up, our part of the presentation. Thank you for listening. Thank you.
Thanks, Jen. Thanks, Lee. Just reminding that if you've got any questions, please pop them into the Q&A tab, which you'll find. I think maybe I'm just wondering, I was just thinking it might be helpful just to have some questions that focus on your presentation before we move to the next one. I'm not sure if that was the rules or if I've broken them, or Anissa wanted me to do it a different way. But one of the questions, and which I was trying to type in, but apparently I don't have access to the Q&A, was actually about the access to those databases that Lee, you pointed out, because of course they looked really appealing and somebody else jumped in with that. But, and of course I tried to Google it as you were talking, and the question is, you know, how difficult is it for translation? Really, can we get access to it, or do we have to use a Chinese-based law firm to really navigate through those databases?
Yeah, I'm afraid like you have to rely on Chinese local counsel to navigate all the process investigation, mainly actually two reasons. One, indeed, the language barrier. It's only available in Chinese language. And secondly, actually, it's more, more about the technical issue because somehow, some websites, it's, run by the Chinese governments. Actually, it's sometimes difficult to access to the websites outside China. So I don't know whether they do it on purpose. So anyway, it's also, legally, and it's also good like for the Chinese local counsel to digest all the information and then make a report for you. So it's not, yeah.
So the message is that it's these databases are available and they're very helpful, but actually you're going to need local counsel in order to make use of them fully. Another question is when can we do it in the insured's name?
For the subrogation claim itself, it should be done in the name of the insurer, not the insurer.
Yes. Yeah. So you have to do it in the insurer.
Yeah.
And what about as a reinsurer of a Chinese insurer ceded? Is that something, what is the position for bringing a subrogation action where you're a reinsurer and you've got a Chinese insurer ceded?
Actually, first of all, actually, we haven't seen a lot of cases, actually very real cases about the reinsurer like subrogation in China. There's no established practice. It really depends on the individual judge, his opinion. But in all, they will follow the principles of the insurance law and the subrogation rules. Yeah.
Right. Okay. And what tactics are recommended when a Chinese manufacturer ignores a letter of claim?
Oh, it happened often. Okay, maybe Jing, you can say something about this because based in Shanghai, normally you're going to deal with this kind of like practical issues. Yes.
Yes, we have issued quite a few letter of demands to manufacturers and suppliers, and we also follow up with these letters if we haven't heard anything from them, if they haven't taken any actions that we request in the letter of demands, or if they sometimes they would reject. Of course, they will reject cooperations. We would also follow up with them by emails and phone calls, and if we can do this pre-litigation investigation on them. We can also check their company files to check their status, or to exhaust all of our measures before actually launching or deciding to launching a lawsuit against them. So, and during this process, it's quite difficult for people who are chasing after them. But we just make sure that all the preparation should be done and can be done by lawyers, and then we prepare for the worst. So the next steps would be the litigations, and if they are not cooperating or not negotiating, not wanting to be involved in any negotiations. So yeah.
Okay. Well, I'll just deal with these last two questions, and then we'll come through to Australia. Does your firm provide no win, no fee services for subrogation actions for foreign insurers?
Feel free to send me an email.
Well done. Good answer. Are the courts critical of uncooperative pre-action conduct?
Jean, you want to take this one?
Sorry, can you come again?
Last question. You want to take this, or are the courts, Chinese courts, critical of uncooperative pre-action conduct? It's a
critical of what? Sorry.
Uncooperative pre-action conduct. I think it's from a common perspective of question. Yes.
What specific aspect do they want to know? Uncooperative.
Why don't we leave that question? If you look at the Q&A tab, you might be able to get it, and we might come back to you. What might do? You see this? Have you got it, Jing? Yeah. Don't worry. We're going to move on to Australia, and we're going to let you just have a moment.
Okay. Yeah.
And So for those who have joined, I introduced Nick Christensen, is a partner in our commercial and corporate and commercial team, who's a dispute resolution specialist with a focus on insolvency. And James Clossy is from the commercial insurance team. So there's a commercial aspect to this, and then there's the insurance aspect. So it's over to you, Nick.
Thanks, Gillian, and thanks everyone for joining us today. We thought that those of you interested in recovery actions in China might also benefit from an update on the current conditions in Australia as another part of the Asia Pacific region. And our colleagues have explained some of the challenges in approaching such actions in China. So as a counterpoint to that, I wanted to just focus today on a couple of key challenges that are currently being faced in recovery and enforcement in the Australian market. And perhaps unsurprisingly, the greatest challenge at the moment in enforcement and debt recovery activity stems from the COVID-19 pandemic, and specifically its effect on commercial matters that are before the Australian courts, and the consequences of some measures that have been implemented by the Australian government to support businesses and individuals by extending timelines for insolvency and bankruptcy action. So to understand the impact, I think it's probably helpful just to very briefly summarise how enforcement would proceed normally. So typically, enforcement begins once you've got a judgment obtained through a civil action in the courts, and then measures to enforce court orders would include things such as public examinations of the debtor before the courts to identify assets, garnishee orders to have access to bank accounts and income, and orders for seizure and the sale of assets. There's also in Australia a simplified demand procedure that applies to corporations, which doesn't always require a judgment debt first, which is a creditor's statutory demand for payment of the debt. And that procedure usually allows 21 days for payment of the debt, after which the company is presumed to be insolvent. Then at the end of that process, almost as the last resort, for individuals, there's an option to pursue proceedings in bankruptcy to bankrupt the individual in the hope of getting something out of the bankruptcy process. And for corporations, the end of the line would be a winding up application through the courts to put the corporate debtor into liquidation. So in terms of the current status of the Australian courts, the position in the court systems for each of the 8 states and territories in Australia and the federal system is slightly different, but there are some common features that I think are broadly consistent across the board. We've found that the pandemic obviously hasn't completely stopped commercial cases being brought altogether, and we're obviously still seeing proceedings being commenced, including for recoveries. But we're finding that there's a much greater level of attention paid at the outset about the target's financial position and the prospects of actually recovering from them. There has been quite a significant drop-off in enforcement action generally, in particular from Australia's bigger banks, where there are things like industry codes or arrangements or policies in place to defer or delay enforcement actions. Or otherwise, there are policy in places with some of the banks and larger corporations to defer or delay enforcement, essentially for public relations purposes. The intermediate and the superior courts, such as the Supreme Courts in the states and the federal court, have all adapted quite well, and cases are certainly moving through the system, including using technology to conduct hearings. And in fact, some of those measures that have been adopted in recent months are so successful that I think they're likely to be made permanent. So for most civil matters, for example, in the New South Wales Supreme Court, they are currently being dealt with at the court's usual capacity and without any real significant delays. The lower courts, however, I think have struggled, and that's resulted in some significant delays in civil cases. That's in part due to resourcing and also because they tend to deal with the bulk of the criminal matters which are being prioritised. So for example, in March of this year, the New South Wales local court, which handles debt claims in New South Wales below 100,000 Australian dollars in value, deferred all hearings and civil matters until at least September of this year. Last month, they made some arrangements to start bringing those matters back on, but we're expecting there'll be a significant backlog as those are cleared. So I think as a result of that, the message is that at the outset of a recovery action, some consideration obviously needs to be given to the additional complexities and the delays in the access to courts. The second thing I want to talk about is that's affecting recovery actions in Australia is the delays to insolvency proceedings that result from measures that the government has taken to support individuals and businesses. So assuming that the target is an individual, once a judgment debt is obtained and assuming all other enforcement options aren't available or have been exhausted, then the next step typically would be to apply to the courts for a bankruptcy order making the individual bankrupt in the hope of recovering some of the debt out of the bankruptcy. Similar procedure applies in relation to a company, provided there's an undisputed debt or judgment debt for $2,000 or more. There's a simplified procedure that I mentioned, the statutory demand procedure, that would typically require the company to pay that debt within 21 days. And if they don't, then there's a presumption that the company is insolvent and the creditor can apply to the court to have a liquidator appointed to the company. Now, obviously, the pandemic has had a significant impact in Australia on the economy, and the country here is in recession for the first time in 29 years. So anticipating the difficulty that's likely to be faced by both individuals and businesses, the government here implemented a suite of temporary measures that are designed to address that. And they've included lifting the threshold for issuing a statutory demand on a corporate debtor from $2,000 to $20,000, extending the minimum time for compliance with those demands from 21 days to 6 months, and relieving company directors from their usual duty to prevent companies trading while insolvent, provided that the debts that are incurred are in the ordinary course of business. And there's been similar measures put in place in respect of individuals and bankruptcy proceedings. So each of those measures is initially to apply until September of this year, but there's talk about those being extended. So the immediate effect of those, I think, is that smaller debts at least can't be enforced through insolvency proceedings in the usual way, so anything less than $20,000. There obviously remains the option to enforce those through the court through seizure and sale orders and that sort of thing, but often it won't be economical to do that. In normal circumstances, the 21-day period to comply with demands is a sufficient threat to a debtor that it will encourage them to either pay the debts or reach a favourable settlement. But at the moment, with the extension of the deadlines for payment to 6 months, the effect is that the debtor can fairly safely ignore those demands at the moment, at least until the end of the extended compliance period. So it's clear that those measures are having the intended effect because there's been a significant drop in the number of voluntary administrations and both corporate and personal insolvencies in Australia over the course of the last 3 months compared to last year. So I think that there's 2 points to be made about what this means for recoveries. Ordinarily, the enforcement processes in Australia are actually relatively straightforward, but at least until September this year, and we think potentially longer, that last resort of enforcement through insolvency proceedings is likely to take considerably longer than usual and be much less effective. And I think that means that particularly where the debtor has substantial assets, it might be worthwhile considering alternative means of enforcement. And obviously there needs to be a lot of consideration given to the timing of those steps and the costs that will be involved. The other factor, I think, is that the reality is these measures will eventually have to be rolled back. And the prediction from analysts and insolvency practitioners at the moment is that that could well cause a wave of insolvencies from debtors in the months to come. So that's what I wanted to cover today, and leave enough time for James, but please feel free to reach out with any questions.
The particular focus that's of interest for the insurers. Thanks.
Thanks very much, Nick and Gillian. Sort of picking up on a few of those themes that Nick spoke about the approach that the government in Australia has taken to make it far more difficult for companies, for creditors to enforce debts, and B, in relation to the distress that a lot of companies are finding themselves in, and indeed the fact that our economy is in the first recession in 29 years. What I was going to consider from an insurance perspective is the ways in which you, for say a product liability case, what you're often going to find is that there is an insurance policy somewhere that might ultimately cover this claim. And so we want to find the policy. We want to then think about how we access the insurance policy, the monies under the insurance policy directly. And lastly, we look at it from the flip side and think about what are the problems that insurers face in relation to these subrogated actions that are being brought against them as a liability insurer, and the manner in which they can seek to defend a case where they no longer have an insured to provide them with information to assist in the defence of the case. The first step, obviously, identifying a policy where you have these distressed companies going into insolvency, or perhaps they're completely deregistered. You can't simply issue a request to the company. What you need to do is the ASIC, which is the body that regulates companies in Australia, will have details of the former directors, and you can issue to those former directors a request that they identify either their insurance broker or who their insurance was with. And there's two ways that you can do this. There's informal requests that you can issue, but basically in every state and territory of Australia, there is a mode of you getting pre-action discovery. Now, there's two types of pre-action discovery: identification discovery and sustainability discovery. Identification discovery is a process by which you interrogate a person, or you require them to give you documents or things which might tend to identify a potential defendant for your action. So what we're thinking here is there's an insurance policy potentially. So I want to interrogate former directors about who was their insurance broker or who was their insurers. I then want to interrogate or issue requests to insurance brokers to say, who did you place company A's liability policy with? And there are legal mechanisms that you can do, because often, and we've all done this on the flip side, these insurance policies are jealously guarded because no one wants anyone to know about the cover that might be available there. If you wish to sue the company, it's incumbent upon the company to go to its insurer in order to seek an indemnity. But this provides that avenue. So once we've found a policy, there's a question of the subrogating insurer bringing an action directly against the insurer who insured our defunct company. There are a range of methods to do it. I've set out some of the acts there. The Corporations Act naturally will be looking at actions against corporations. The Bankruptcy Act is actions against individuals. In New South Wales, there's a specific act that deals with it. The broad tenets that sit behind each of those acts is A, that a subrogating insurer seeking to bring a recovery does not then seek either dual insurance contribution, nor are they seeking to say that their insured gets insurance under the other party's policy. What they're really doing is making the insurer of the defunct company sit in the shoes of their insured to defend the action. Now, the problem with this is that that insurer might say that they have indemnity arguments that they want to run. They might say that the policy doesn't cover this loss. What these acts basically do is try and strike a balance between the right of the party seeking to enforce a debt, that if there was an insurance policy there that would have covered it, it should probably pay the debt, but balancing that with the insurer's right to say, I don't want to be put in all of this spurious litigation where these claims are never going to be covered. So what these acts do is they balance it by a requirement, generally speaking, that leave be granted in order to pursue the insurer. And that's what the courts here use as a control in order to stop these spurious claims being made. I note the time, so I'll sort of skim over that, but those are the broad ideas that sit behind those policies. Finally, the problem for insurers is obviously when you're getting this claim and you have no insured from whom you can get documents or information, you then 9 times out of 10, a liability insurer will have a condition in their policy saying, well, you have to cooperate with our attempts to defend you. And if you don't, that's a breach of the term of the policy. The problem in Australia is Section 54 of the Insurance Contracts Act. Whilst in other jurisdictions you might be able to rely on a breach of a condition precedent to the policy to say there's a breach of a condition, therefore there is no cover, our Insurance Contracts Act effectively says that you can only demonstrate, only to the extent that the insurer can demonstrate that they are prejudiced by reason of the insured's breach of that condition, that they can then rely on the breach to reduce their liability to pay the claim. There's a lot of very complex concepts rolled up in that, but the fundamental effect of it is that if you're sitting as an insurer saying, I have no cooperation, you are going to have to do a lot of work to try and get cooperation in order to meet the relevant thresholds that you need to meet under the Insurance Contracts Act to rely on those provisions. It will be a very high and difficult bar for an insurer to meet to avoid a claim entirely because their insured is defunct. I think given the time that's probably as deep as we can go into those issues.
Yeah, thanks, James. I mean, really, you've just skipped across the highlights of it, which is helpful. And with Nick's, we've got a bit of a perspective as to what Australia is facing and how we might manage those sorts of recoveries. So thank you. And thank you everybody for participating in our webinar today. I know that half of you are rushing to get off to 9:30 meetings, and some of you are at 4:30 in the afternoon in Shanghai and whatnot, and here in Australia at 6:30. So you probably can guess what we're keen to do. So Anissa from GILC will be circulating a feedback form. We'd really appreciate you just giving some feedback on it. Oh, sorry, we've got a question here, Joanne. Have the legislative changes mentioned actually come into force yet?
I think the answer for that for both Nick and my presentations is yes. Yes,
okay, good-o. Okay, I think, is that it, Anissa? Have I got permission yes, so Anissa's telling me that to encourage you to do the feedback as we go through, so as you come off. So thank you very much, everybody. Have great days and great evenings, and we'll talk to you again. Thank you.
Thank you all.
Thanks to you.
Thanks.
Yeah.
Thank you. Bye, Lee.
Bye.
Bye.
Bye. Bye, Julian. Bye.
Thanks very much. Okay, bye-bye. Bye.